Hello, everybody. Hello, Sir Philip. Hello, Mortimer Duke. We're getting a thunderstorm. Hello, Nana Laura. Hello, S. Buford. Oh, give me a second. Tommy, can you please go check for a package? Yeah. Thank you. I can't at the moment. I'm somewhere I have to be. Hello, Sherry B. And hello, Joey Bag of Donuts. Aww. I don't know why that happened. Or didn't happen, I should say. We got a fun one. We've got, thank you. We've got a genuine Moorish American. I got a present from S. Buford. I'm glad they put it in the porch because it'd be soaked right now. I don't want to, the top is bowed and I don't want to cut through the top. Oh, I would have only got package paper. Oh, wow. You don't know how bad I wanted one of these. It's a dash cam. No way. Thank you so much. I was actually in Best Buy looking at dash cams and I didn't get it because the installation guy wasn't there. I'm so glad that he had the day off. Oh my gosh. I think everybody should have a dash cam. I really do. And now I do. Oh my gosh. Hello, Eileen E. Carlin. And yes, it is. That is so sweet. Oh my goodness, thank you. You absolutely made my day. Hello, Spider-Man. Oh my gosh. I am seriously, I am the luckiest person in the entire world. S. Buford, thank you so much. Hello, Terry Barnes with the big Kentucky hugs. Okay, guys, you ready to see this? Let's watch this poor Moorish man.
Okay, and we are ready to start recording. We're live on the record in cause number 24 FD 487. This is an original petition and suit affecting the parent-child relationship with an acknowledgement of paternity. One of you is in a room with a lot of noise. Is that able to be? I'm not sure who it is.
Let me close the door.
Okay, thank you, ma'am. It's very distracting.
Okay.
Yeah, if you ever participate on Zoom again for hearings, whether it's before me or another judge, just be aware it needs to be a quiet location so you can still participate like the courtroom would be. Okay, so we are live on the record in 24 FD 2487. This is an original petition and suit affecting the parent-child relationship with an acknowledgement of paternity. And this was filed by the Attorney General's office on December 6th of 2024. All parties are present on Zoom today, and this is a remote proceeding. And I am sitting outside of Galveston County pursuant to the Texas Family Code, Section 201.1045. And I find nobody has objected to proceeding in this manner. Mr. Millard, can you state your full name for the record, please?
Yes, my name is Sidney Millard Bay.
Have you legally changed your name?
Yes,
Okay, so you have a social security card with Bay? And then,
no,
okay, do you have a driver's license with Bay?
no.
Do you have a birth certificate with Bay?
Ma'am, I challenged jurisdiction and we
Yes, and that was
haven't.
denied, sir, so we are proceeding.
Well, I'd like to proceed to a de novo hearing.
Have you filed that request with the court?
I did. It should be in your paperwork.
Judge, I don't see a de novo filed on Odyssey.
Don't either. You filed that with the district clerk's office?
I did. It was mailed on the 26th.
They might not have received it yet.
It should have been there.
When did you mail that, sir? You said the 26th?
Yes,
Is that timely, Mr. Dehamian?
No, Your Honor, typically de novos are done within 3 days of a judge's ruling. There hasn't been a substantive ruling in this case. But there's nothing e-filed on Odyssey regardless. The only ruling in this case is that his lack of jurisdiction was denied.
Checking with the clerk. And before we begin, let me swear you in, sir, because even what you just said to me was not said under oath. So again, your legal name is, what is your legal name, sir?
Sidney, capital SIDNEY, Millard, capital MILLARD, Bay, capital BEY.
Oh no, he put it wrong on the Zoom screen, or they put it wrong. It's all lowercase. I wonder if that has the same effect as all caps.
Can you, and Miss Blake, can you state your full name for the record, please? I think she's frozen, so we're going to have to wait for her.
Hello?
Ma'am, I think you were frozen. Are you able to hear?
Yeah. Yeah.
Okay, what is your full name, ma'am?
Sonora Blake. Sonora Marie Blake.
Okay, and sir, was your name, are you the person who also goes by Sidney, Sidney Somerville Millard IV?
No,
That is not you? That was
that
never
is
you?
that is my all caps name. That's not the name that I have.
Are you saying that's a different person though?
No, I'm saying that I am not that person.
Now, Judge, he has sent a de novo to the state, but he hadn't filed it with the court.
Sir, where did you well, if you can both please raise your right hands to be sworn in. Do you each solemnly swear that any testimony you give today will be the truth, the whole truth, and nothing but the truth?
I affirm.
Yes.
Okay. So sir, where did you mail your request to on April 26th?
I mailed it to the Lamarck office.
Okay, so you did not file it with the court. Mr. Division, are you able to read what it was? I just want to make sure it was a de novo and not a new trial.
Yes.
See, Judge, I can share the screen if you would like.
I asked you to read it.
Okay. So the title, it's non-standard. The title he wrote request for de novo hearing. Then he's got his name, and he's got an address, and underneath that he's attempted to put a style, and then he titled it Nunc Pro Tunc, and then underneath that he's got request for de novo. Then he's got another title saying notice to the court, requesting de novo hearing concerning the denial of my affidavit of fact of dismissal of lack of jurisdiction. I am requesting de novo hearing on the following grounds. And he cited several cases, which is not relevant. And there's a page 2, and he's talking about the post box rule, which is also not relevant. And then he signed it on page 3, and he's got a jurat.
Objection.
What's
I
your
believe,
legal objection,
I believe
sir?
that everything here is relevant.
Okay. I'm going to sustain your objection. However, I don't know if it's denying, but I'm going to find that your de novo request, I don't need to wait for that because it was not filed with the court and it was not filed timely, even if I considered the AG's office the court, which I do not.
Can you repeat that? I didn't
You
hear
did not file it with the court and you did not timely file it, even if you had filed it with the court. So we're moving forward today. Mr. Dehamajian, you may call your first witness.
Thank you,
you.
Judge.
Well, hold on, Your Honor. I have a question. Like, you saying that it wasn't in a timely manner, but it was on the 26th, and notice to agent is notice to principal. Notice to principal is notice to agent. Once it's in their hands, it's in your hands.
I cannot give legal advice. I'm denying, well, it's not even filed. I'm finding it's not filed with the court and it is not timely. You may proceed, Mr. Dehamajian.
Thank you, Judge. Judge, at this time, the state requests that you take judicial notice of our petition filed on December 6, 2024.
I take judicial notice of the pleading, including the acknowledgement of paternity that was signed by both parties with their all caps names.
Thank you, Judge. And the state calls Ms. Blake. Ms. Blake, can you state your name for the record?
Sonora Marie Blake.
Ms. Blake, who is your child?
Raheem Ali Malloy.
And how old is he?
13.
Okay. Now, when you make decisions, important decisions for the child, do you consult it with his father?
Yes, it depends on what the situation is.
Okay. And you're asking for joint managing conservatorship, right, ma'am? Where you continue
How old
making.
is this child?
How old is the child, ma'am?
13.
Okay. And you're in agreement as to keeping it wanting joint managing conservatorship where you continue to make decisions together, right?
Yes.
Okay. Now, what's the visitation with the child with dad right now? When does he get the child?
Whenever he likes.
Okay. And the child and the child and dad, they have a good visitation, good relationship.
Yes.
Okay. And you wouldn't you're not against that the visitation be the standard possession order in this case, right?
No.
Okay. Now, the geographic, are you asking that be no restrictions, ma'am, where you make your home with the child?
Yes.
Okay. And why are you wanting no restrictions?
Because I don't have a problem with moving places to where he's able to still see him. It doesn't matter where we at, he can still be able to see him and come get him.
Okay.
And he goes
Now,
to school here.
okay. So do you have any plans to move in the future?
Not at the moment.
Do you have any job offers outside in other states or any other place?
Not at the moment, I don't.
Okay.
And ma'am, you're
But-
in Galveston County?
Yes, ma'am.
Have you lived outside of Galveston County since your child's been born?
No, ma'am.
May I continue, ma'am? Your Honor.
You may.
Ma'am, what type of health and dental insurance is the child on right now?
Medicaid, children's Medicaid, I think it is.
Okay. Now, do you know what Mr. Millard does for a living, ma'am?
He used to work as a lineman, fixing on the light poles and stuff, but now I too much don't really know.
Okay.
I've seen
you know-
the truck. I don't know. I think he drives trucks. I don't know.
Do you know
I'm
if he's
not for sure.
Do you know if he's retired?
Yeah, he don't work for them no more.
Okay. Now you said truck. What kind of truck does he drive?
I just seen a big truck, like I don't know. I guess there's 18 wheelers. I don't know what kind of truck it was. I don't know.
It's a big 18-wheeler truck.
Yes,
And where did you see that 18-wheeler truck?
I just seen a picture of it on my son's phone. On Facebook.
And where was it parked?
Oh, I don't know. It was parking lot or somewhere. I don't know exactly.
Do you believe that he's driving a truck right now?
I don't know. There's a possibility.
Okay. Now, let's talk about retroactive child support. Has he given you any monies in the last 4 years to support your child, ma'am?
Yes, off and on.
If you're
a
gonna-
request.
If you're going to put a dollar
I'm
amount, how
sorry,
much is
Mr. Davidson, you interrupted her last word. I couldn't hear it. What did you say at the end, ma'am?
I said yes when I asked request for it.
Okay.
if you're going to put a dollar amount, ma'am, how much has he given you in the last 4 years?
All together, what I added up, that I had on my Cash App, it was like 3,300.
Okay. Let me ask you this. Have y'all ever lived under the same household?
No, not living.
Okay. Ma'am, do you know if he's got other kids?
Yes.
How many other kids does he have?
There's 6 altogether, and
Objection.
One moment. Okay.
Five.
Ma'am, one moment. What is your legal objection, sir?
What's the relevance of my kids being drug into this? Like, I don't understand.
Court calculation, sir. You may proceed, Ms. Blake, and I couldn't hear anything you said. So if you can repeat your answer.
6 altogether, about 5 that's living.
Okay. The number of children you have only benefits you, to be honest, sir.
Okay, so are you saying one is deceased, ma'am?
Yes, ma'am. Yes, sir.
Okay. And so not counting the one child in this case, there's 4 children outside this case, right?
Yeah.
Okay.
But I only have one with him.
Okay. The 4 kids outside this case, are they all adults? Are they all over 18?
Yes.
Okay.
Are any of them in high school still?
No.
Pass the witness, Your Honor.
Okay. You may call your next witness.
Your Honor, I call Miss Tatiana Young-Fleeton. I don't know if she's been sworn in yet, Your Honor.
Don't believe she has. Can you state your full name for the record, please?
Tosiania Young-Fleeton.
And can you please raise your right hand to be sworn in? Do you solemnly swear that any testimony you give today will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you. You can lower your hand. Proceed.
Thank you, Judge. Ms. Fleeton, who do you work for, ma'am?
The Office of the Attorney General,
And how long have you been working for the Office of the Attorney General?
18 years.
And what do you do there, ma'am?
I'm a child support officer. I calculate child support, medical support, and dental support, and retroactive child support, medical support, and dental support.
Ma'am, what did you calculate in this case?
Retroactive child support.
And what were your findings there?
For the year 2021, minimum wage, gross $1256.67, net $1159.87 for 12 months, at a total of $232 a month, based on 20%, for a total of $2,784. Excuse me. For 2022, minimum wage $1256.67, net $1159.87 at 12 months, at a total of $232 based on 20%, for a total of $2,784. For 2023, gross minimum wage $1256.67, net $1159.87 for 9 months, at a total of $232 based on 20%, for a total of $2,088. Also for 2023, for 3 months, gross $2,119.80, net $1,870.66. For 3 months at $374 based on 20%, for a total of $1,122. For 2024, gross $4,092, net $3,457.80 for 3 months at $692 based on 20%, for a total of $2,076. For 2024, minimum wage, gross $1256.67, net $1159.87 at 9 months at $232 based on 20%, for a total of $2,088. And for 2025, gross $1256.67 minimum wage, net $1159.87 at 4 months at $232 based on 20%, for a total of $928. The subtotal $13,870 with a credit of $3,300 for a total of $10,570.
Judge, at this time, I offer State's Exhibit 1, which is the retrocalc based on Ms. Fleeton's testimony.
Don't see the case is even open for today. Does it have a date? Tech work. That's the right hearing date. Anyone have any objection to me entering the exhibit? What was it, State's Exhibit?
1, Your Honor.
State's Exhibit 1.
Yes.
Ms. Blake, do you have any objection to State's Exhibit 1?
No, ma'am.
And Mr. Millar, do you have any objection to State's Exhibit 1 being admitted into evidence?
I do object.
What is your legal objection?
My objection is that I don't wish to contract. I don't have a reason to contract. I do enough already for Sonora and my son.
Okay. I'm going to overrule that objection and admit this into evidence. And do know, sir, you'll get a chance to explain why you don't believe back child support is appropriate. State's Exhibit 1 is admitted, and you may continue, Mr. Dehmasian.
Judge, I pass the witness, Ms. Fleeton.
Okay. You may call your next. Oh, actually, Mr. Millard, do you have any questions for Ms. Young-Fleeton?
I only object to this proceeding because I moved to dismiss. There's no reason for this, and you all have me here.
Okay. I'm overruling the objection. Ms. Blake, do you have any questions for Ms. Young-Fleeton?
No, ma'am.
Okay. You may call your next witness, Mr. Dehmasian.
Thank you, Judge. I call Mr. Millard. Mr. Millard, can you state your name for the record?
Sydney Millard Bay.
Mr. Millard, what do you do for a living, sir?
I have a question. I'd like to know the the proper names for yourself, the judge, and the other officer that was here.
Judge,
I
objection,
believe
non-responsive.
I believe that there's a conflict of interest here because at least two of you work for the state.
Okay, I'm going to overrule the objection. My name is Judge Jennifer Baker. Mr. Gary DeHamajan, his name is written right there on the screen. Miss Tosiana Young-Fleeton, her name is on the screen as well. So you may proceed, Mr.
And
DeHamajan.
who are they employed by?
Sir, it says they work for the Office of the Attorney General. You may proceed, Mr. DeHamajan.
Sir,
So everyone works for the Office of the Attorney General?
I don't. You may proceed, Mr. DeHamajan.
Mr. Millard, what do you do for a living?
So you work for the state? We're
Objection, non-responsive.
Sustained. Sir, please answer the questions.
I don't work.
Are you retired?
I don't understand. I don't understand where we're going here. I already said what I need to say in this matter, but you guys keep pushing forward. So I'm telling you that I don't want a contract, and you're steady trying to draw me into your jurisdiction, and that's not what I want.
Sir, do you own an 18-wheeler?
I don't understand.
Do you drive a truck for a living, sir?
I don't understand. I don't understand.
Are you refusing to answer my questions, Mr. Millard?
I move the court to dismiss.
I'm denying that request. You may proceed, Mr. DeHamajan.
Mr. Millard, do you live in a home or an apartment?
I live within myself.
Do you pay rent?
Excuse me. I live within myself.
Do you own a car, sir?
I move the court to dismiss.
I'm denying that
Objection.
request. Sir, please answer the question so I can make an appropriate ruling in your case. This is not a contract. International Shoe says I have jurisdiction of you. You were served in Texas. This child lives in Galveston County. We are proceeding with the Attorney General's petition.
I don't understand.
Do you pay rent, sir?
I don't understand.
Do you have a car?
I don't understand.
Judge, the witness is refusing to answer questions.
He's saying he doesn't understand. He might not understand.
Hmm.
Just ask your questions to the best of your ability, and I'll make my ruling to the best of my ability.
Okay.
You can impeach him if you have impeachment evidence.
Mr. Millard, do you own a phone?
I don't understand.
What are you using for Zoom, sir? What device are you using?
This is a tablet.
Okay, so you own a tablet. Do you know what a phone is? Do you know what a telephone is? Maybe he needed to use the full word.
Do you own a phone, sir?
I don't understand.
Which part of that did you not understand so he can break it down for you?
Any of it. Like I
You know-
I don't understand these proceedings. I don't even understand why I'm here. Like I told you guys that I don't want a contract. I don't need to contract.
Sir,
And I asked the court to move to dismiss.
I'm denying that. This is your chance to provide evidence, sir. Otherwise, I'm just going to make my ruling. without
Evidence
your-
of what? Of
The
what? That I'm
issues
here?
before me, sir, I can't give legal advice, but I can let you know the issues before me are conservatorship, possession and access, support, child support, medical support, dental support, and back child support. So that is what I'm going to be ordering today.
And I already do all of that, John. So I object to this whole thing.
I understand you object, sir, and I'm overruling your objection. Mr. DeHamajan, do you feel you need any more testimony from Mr. Bay?
No, Judge. I passed the witness.
Do you have any other witnesses?
I recall Ms. Blake just briefly.
Okay, you may do so.
Ms. Blake,
Yeah.
do you, you could just answer to the best of your knowledge. Do you know if Mr. Millard lives in a home or an apartment?
I think he live in a home.
Do you know if he how many vehicles does he have?
No, I don't know.
Okay. Pass the witness, Your Honor.
The state does not represent either party, so I'm going to give you each a chance to let me know if there's anything additional regarding those issues that I just described. Ms. Blake, is there anything additional you'd like to say?
No, ma'am.
Okay, thank you. And Mr. Millard, is there anything additional you'd like to say?
Yes, I'd like the court to move to dismiss. I object to all of these proceedings.
I'm going to make my ruling and render based on the testimony presented. Before I rule, I'm letting each party know that you do have a right to a de novo hearing before the referring court regarding any decisions I make. That request must be filed with the district clerk's office. I am finding, once again, there is jurisdiction over this matter. The child lives in Galveston and Mr. Millard was served in Texas. Those service papers are on file with Galveston County as reflected in my previous ruling. I'm appointing the parties joint managing conservators with Ms. Blake having the right to determine the primary residence of the children within Galveston and contiguous counties, or any county that touches Galveston. Before I continue, Mr. Dehamajan, do you have any requests regarding medical support or child support?
Yes, Your Honor. We do have
I'll
a
just- No need. You didn't present it. I'm going to just create a child support amount. Bear with me. Okay. I'm setting child support based on minimum wage. There's one child before the court and no others. I'm finding that nobody has access to private insurance at a reasonable cost. I'm ordering that Mr. Millard pay to Ms. Blake cash medical support of $35 per month beginning May
Objection, Your Honor.
2025. Sir, let me get through my ruling. Beginning May 1st.
I have a question.
Sir, let me get through my ruling and then you
I
can
have
ask-
medical insurance for my
Let
son.
me- Okay, you did not testify to that and you said it was you. I think you might have objected to the question. So where do you have medical insurance available?
I didn't hear the question.
Okay, what insurance? How do you have insurance for your son? Is it through a job? Is it through the marketplace? Is it through a relative? Is it?
Proceed, Your Honor.
No, this is important. Where is the insurance from? I don't know.
It's through a marketplace.
Okay, so you have gone on the marketplace and you purchased insurance? Is that true? That's what you're saying? You went online and purchased insurance, or you called and purchased insurance?
Yes.
Okay. What company is that through?
I don't know. I don't have the documents in front of me.
Have you provided Ms. Blake with those documents so she can use the insurance?
I did.
Okay. And do you know how much it costs per month?
I don't remember.
Is there a place you could go look that information up? It will
Not
affect
right
your
now.
child support and it will make your child support lower. So it will help you to look up this information.
I don't know, Your Honor. I don't have the information with me right now.
Okay, are you in your house right now? You don't have it anywhere in your house.
Go ahead, Your Honor.
Ms. Blake, do you know that he has private insurance? Ms. Blake, has he given you the cards? You have to answer out loud.
Hold on. Let me look on my phone before I say. Was it a card? I think it was a card. Okay, it's what is this? I have a card he sent me. It's a discount card. It don't have an amount on here.
Good RX is not insurance.
Hello?
We're listening to you, ma'am.
Ma'am?
We're listening.
Yes, I pulled up a card. I pulled up a card that he sent me, but it doesn't have a amount on here. It just says benefit level, individual, children, the group number,
What
member
company?
ID, NCE. It says a discount card. That's what it says on there. I don't know if you can see it or not. See if you can see it. Did you see?
No, do you
Hold
want
on, hold
to
on.
send that to the Attorney General's office so they can look at it?
Yes.
So are you on this insurance as well, Mr. Millard?
I just only, oh, I'm sorry. I only see his name on there. I don't see Raheem's name on here. I'll be a mother.
Ma'am, please remember
Oh,
your report. Please watch your language.
Ms. Blake, I just sent you an email. If you could forward that to me. Ms. Blake, can you hear me?
I think she just lost connectivity.
Judge, we're trying to call her right now to log back on.
She might.
I have a question, Your Honor. Do you have an address for the de novo hearing? For me to send the de novo hearing to?
It is the district clerk's office in Galveston County. I don't have the address. Ms. Maripis, if you can look that up. Or sir, you can Google it. Right now she's not here, so if you want to take the time to Google that, you may.
And he said it's in Galveston.
Yes, it's the courthouse in Galveston County, Texas. Galveston County District Clerk's office. I don't know what address they use.
I just got off the phone with her. Her phone died. She'll be logging in shortly.
We're gonna wait for her.
Judge, would you still need her to be on video at this point, or can she just call in?
No, she needs to be on video. She might need to drive somewhere where she has good reception. She knew she had this hearing today.
Okay. Ms. Blake, can you turn your video on?
hello?
Can you turn your video on, Ms. Blake?
Hello?
Yes, I can hear you. Can you hear me?
They can't hear me.
There you go. We can see you.
Hello? Hello?
Hello, can you hear us? Can you hear me? Can you hear me, Ms. Blake? Can you hear me, Ms. Blake? Hello? Can you hear me now?
I think she's back in the house, but she might not have turned her Bluetooth on.
Can you hear me, Ms. Blake, now?
Yes.
Good. Looks like you're back.
Yeah.
Thank you, ma'am.
Mm-hmm.
Ms. Blake, did you see my email?
Hold on. Yes.
Okay, can you forward me that card that you were talking about? That discount card?
Okay. Did it come through?
Did you send it?
It says sending. Hold on. I sent it. I don't know if it's two cards.
Okay. Well, give me a second. Hopefully it'll come through in a minute.
Okay. Probably the Wi-Fi signal ain't no telling. Hello?
Oh, we're still here.
Oh. Okay, the other card that was on there is from American Financial Security Life Insurance Company. And it has Sidney Millard name and the dependent Raheem Millard child. The effective date was 11/26/2024.
Yeah.
Do you need the member ID on it? If that'll help, if it didn't come through.
No, I would need to see the card.
Oh, okay. Let's see. Is it okay to send it back to Sydney and let him send it to you through his email?
Have you have you tried sending it to me?
Yes.
Did it go through? Do you know if it saying that it was successful or it's sent?
Hold on, let me check.
It's totally ridiculous.
No, no, Mr. Man in the funny hat, you do not get to be the judge of what is or is not ridiculous.
Please attach. It said it's in a queued, whatever that is. How do you do that? Hello?
Yes.
Is it okay to send it back to Sidney Malloy's phone and then he can send it to you through his email?
It's up to you, ma'am, if that's what you want to do.
Okay, because I really don't know how to do this email thing.
Oh, for goodness sakes, it's because you're on the phone call right now, and you probably don't have a phone that's dual band capable where it can be accessing internet and phone at the same time.
Judge,
Yes,
so we've Googled NCE
do we
and
need to be on the record? Why don't we get on the record?
yes, Your Honor, please.
We can start the recording again. Okay. So yes,
So, Your Honor, we've found something out. We've Googled NCE, and it's like what Mom said. It's a discount card. It's not insurance.
okay,
So I don't know if that would help the court finish its ruling.
that does help. Sir, do you know anything else beyond that, Mr. Millard?
Objection, Your Honor. She just read the other name of the card for the insurance.
The other was, I believe, well,
There's life insurance.
so do you have any other health insurance
It's
available?
medical insurance, Your Honor.
Okay, can you provide some testimony about that? So, because I can only rule based on evidence before me, I can't go investigate.
That's fine.
And I can't, so I want to hear this testimony, but you need to provide it, sir, because no one
That's
else has
fine.
information. It's not
It's fine.
fine. I'm supposed to order insurance through your job if you have it, or then through another source if you have it. And then a state plan is supposed to be last on the priority list. So if you have it through another source, which it sounds like you might, I should be ordering that. But I need evidence to do that, sir.
I don't have it. That's
Okay. Okay, does anyone have anything else they'd like to say before I conclude my ruling? Okay, so render judgment. I'm ordering the parties joint managing conservators with Ms. Blake having the right to determine the primary residence of the child within Galveston or any county that touches Galveston County. Ordering that Mr. Millard has visitation pursuant to the pursuant to the standard possession order. I'm finding nobody has access to private health insurance at a reasonable cost, so I'm ordering that Mr. Millard pay to Ms. Blake cash medical support of $35 per month beginning May 1st of 2025. Finding nobody has access to dental insurance at a reasonable cost. I'm ordering that Mr. Millard, is Ms. Blake here?
Yes, I'm here.
Okay, if you can stay on camera, ma'am,
Oh, sorry.
you're in court. Mr. Millard, thank you for staying on camera. I'm ordering that Mr. Millard pay to Ms. Blake child support of $225 each month beginning May 1st, 2025. And based on the testimony provided today and evidence presented, I'm ordering back child support in the amount of $6,500 as of today, April 28th, 2025. That's a back child support judgment against Mr. Millard. It will accrue interest for the family code at a rate of 6% per annum. It is not an installment debt. Other remedies can be used to collect this if appropriate. However, I am ordering that Mr. Millard pay to Ms. Blake $50 each month beginning May 1st, 2025 towards that judgment, with a step up to $275 when child support ceases per the family code. And I'm ordering that Mr. Millard pay court costs as billed to Galveston County by April 28th, 2026. The state is going to draft the order based on my ruling today, and they'll be sending it to both of you through DocuSign to review and sign. If you don't sign it, they will be submitting it to me, and I will confirm that it matches my ruling and sign off on it. So we're going to have you all go back to your breakout rooms, or you'll get a chance to review the order in private and confirm it matches the ruling. But thank you both for coming in, and good luck going forward with everything.
Yes, I looked it up, and that is the flag of Morocco, adopted in 1915. So the green 5-pointed star on a red field, and it says that it's to symbolize the 5 pillars of Islam, and the red is associated with the Alawid dynasty. So that's per Google. No. I have a feeling that he doesn't pay for his other either 4 or 5 children. At first she said 5 because she said 6 altogether. So with her 1, that would be 5 others. But then when the AAG crossed her on it, he said, now he has 4 other children other than yours? And she said, yes. I don't know how that adds up to 6. I was very confused. Oh, thank you. I didn't catch that part. I did not catch that. I missed it. Thank you guys. Thank you. Are you kidding? That flag, he got that. He got that on Amazon like a week ago. It still has all of its creases. It's never flown. Oh my gosh. I don't even think he could spell Morocco. I mean, we just saw him. That man was not bright. Of course, the woman, I mean, high five to the face, y'all. Oh my goodness. It did. It had every little tiny square. You could still see the creases. I could have probably taken that flag off the wall and refolded it perfectly just by following the lines. See, I have the crying Fez right there in the background. I just wore the shirt on my last stream, and so I didn't want to wear it twice in a row. So I figured I would just display it. The crying Fez. I still love that thing so much. Oh, hello, Bad Scooter, my love. Thank you. I gotta be really close. I really gotta be close. Yay, we got a naughty joke from Sir Philip. My goodness. That never happens. He's always trying to pick on me like I'm the naughty one. Let's see here. Where am I at? I am at 4,745. I am close, y'all. Oh, I'm so happy to see you. Hello, plausible reliability. Yes, yes, they are. I'd sure appreciate it. I still have the Judge Hart from a couple days ago from Mortimer Duke's suggestions. And yeah, if y'all want, we can watch that. We can watch that. Let me see. I just gotta find it. Oh, it's probably already in the folder.
Your Honor, I should probably do a breakout with Ms. Seifkin.
Okay. And the court would ask Mandy when she's able to place Mr. Watts and Miss Seifkin in Court Security 2 into a breakout room. Thank you. All right, we'll go ahead and go on the record, and this is in regards to State of Kansas versus Lindsay Seifkin, 16 CR 652. The State of Kansas appears by Assistant Butler County Attorney Amber Norris. The defendant, Ms. Seifkin, appears in person and by court-appointed counsel Jim Watts. Also appearing at this time is Intensive Supervision Officer with Community Corrections, Teresa Stanfield. This matter does regularly come back before the court on a warrant to show cause as to why the defendant, Ms. Seifkin, should not be revoked from her probation. And announcements to the court at this point, Mr. Watts. And Mr. Watts, you're on mute.
If I remember correctly, Your Honor, and my notes reflect as well, we were last here on March 7. There was a stipulation on at least some of the allegations, and we were here only for disposition rather than determination of whether or not she's in violation.
Thank you, Mr. Watts. The court stands corrected. That is correct. March the 7th, there was admission made by Ms. Seifkin to the violations. This matter is only back before the court in regards to disposition. And recommendations for disposition, Ms. Norris.
Your Honor, this is defendant's fourth warrant to show cause in this case. As the court is aware, this is a 2016 case. She was originally placed on probation on August 10 of 2017. Since then, she has been back before the court. Like I said, this would be the fourth warrant to show cause. And this warrant actually has been pending and outstanding since basically the end of July of 2024. Your Honor, she has had several modifications to basically extend the probation. There's a significant amount of restitution that is due and owing in this case. But Your Honor, she seems to generally pull things together a lot of times around the warrants to show cause, either right before the court does disposition of them or right after. She actually made a first appearance on this warrant to show cause back on January 3rd of 2025. So this has been dragged out for months based on defendants' requests for continuance. I think to try and get or try and appear to have her life back in order and appear that she is actually taking her probation seriously and working on her probation. As previously noted, she does have a significant amount of restitution, but I don't believe that she's, constantly maintained employment. She does have employment now. And she definitely has some mental health issues, which it appears that she is addressing at the moment, but has neglected at other times. Your Honor, it's my understanding that Miss Stanfield is now, as of, in the last few weeks, willing to continue to supervise Miss Siefken. But when I spoke to her a couple months ago, it was more along the lines of, she's never going to get it. She doesn't follow through, and we might as well revoke her because this is the fourth time that we've had to be here, and this case is quite old. And Your Honor, I guess the state would still be of the same mind that this case is quite old. She does seem to have maybe, gotten herself a little bit together for purposes of this hearing. But we just keep dragging this out, and it kind of feels like the same sort of issues. And these actually are fairly significant issues that she stipulated to, that she's having contact with law enforcement, and she's not showing proof of, or she hadn't been showing proof of employment or payments, which obviously are big issues in this case because of how much restitution there is due and owing. But Your Honor, she basically stipulated to not reporting as well. So, Your Honor, these are significant violations of her probation. They are similar to past violations that she has had and seen the court for. And at this juncture, Your Honor, the underlying sentence in this case is 12 months. She has very little jail time credit. So Your Honor, state would be asking that the court revoke defendant's probation and that she ordered to serve the balance of the underlying sentence, and that the money that is due be forwarded to collections. And basically in the almost 10 years this case has been pending, very little of that has been paid or collected. So I'm not sure that extending her on probation is actually going to change the amount of actual restitution that the victim in this case actually is going to receive based on her track record. And the court will need to address additional court-appointed attorney's fees and the bids application fee. Thank you.
Thank you, Ms. Norris. Recommendations from Intensive Supervision Officer Teresa Stanfield with Community Corrections. And Ms. Stanfield, you're muted.
Okay, can you hear me?
Yes.
Okay. Well, as Ms. Norris said, she's really made a turnaround since being arrested. She does have a good job now, making $24 an hour. She has been reporting as directed. And I just, as of recently on April 14th, I received updated progress reports from her therapist and from her medication person. And her attendance has been exemplary, and she has been attending all sessions. I think her biggest issue is the mental health. when depression hits her, it hits her hard, and she just does not function. She just drops off the edge of the earth, and I don't hear from her, and she loses her job, loses her house. But she has got some stability now. She has her own, she's back in her own house. She's got visitation with her son again. And she did make a payment this week. So I know that's a big thing is the restitution and to pay the victims. As I emailed Miss Norris earlier, I'm very willing to continue to supervise her. But this, if she is reinstated, this has to be the last time. I just can't, I guess, put up with any more F cases or law enforcement contact, or, I mean, enough is enough. But I am, at this point, I'm still willing to supervise her. I do believe she needs a sanction of some sort. But that's where I stand.
Thank you, Ms. Stanfield. And recommendations, Mr. Watts.
Thank you, Your Honor. Your Honor, I'll tell you that bluntly, this is a difficult case to make an advocate for. This case has been around since the original conviction was in 2017. The interesting thing about this is that from 2017 until at least on my file, until 2017 to 2022, there did not appear to be any revocation hearings. There may have been some dips or dunks along that time, but she was not back before the court. What's apparent since that time is that her mental health she has struggled with. She sent me, Your Honor, a packet of stuff. There's probably 60 to 70 pages. Much of this having to do with the child support and child custody issues out of Texas. I know she is now basically at least part-time single parent. In fact, I think this weekend was her visitation weekend. Is that right, Lindsay? And one thing that pops out from these court records out of Texas is how much struggling with mental health has been a part of what she's been dealing with. I have records from a group called Soma Therapy, where she is going as of January and February. It sounds like she's continuing going that Ms. Stanfield's aware of. The biggest thing she has going for her is a job, and a job that's paying her. And I have paycheck stubs from, make sure I get the dates here, January 30 and January 23. And again, it sounds like Ms. Stanfield has more current ones than I do. With Jordan Companies, where she's making decent money. One of the natures of what she was convicted of, and she has this massive restitution pile to pay back. It's over $40,000. It's a lot. But because of the nature of her conviction and because of the nature of what she has to pay back, it's all but impossible to get the kind of job that lets her to pay that back. Any place where she has to handle money, they won't hire her for obvious reasons. And I understand why they want to do that. But that puts her in the position of having to pay back enormous restitution without any resources to pay it back. And no one that will hire her to get those resources to pay it back. I mean, Ms. Seekin relates not even working at fast food, because working at fast food that she has to handle money, and where she's handling money, they want to hire her. Particularly if she has to handle credit cards or debit cards, which in today's economy is literally everything.
She put herself in that position. She can't be mad at anyone but herself for that.
Most of us use very little cash anymore. And aside from the business, I can't remember the last time I wrote a check. So for the first time in a long time, she has actual income with Jordan Companies. And I asked Ms. Seifkin this directly. Realistically, and still being able to eat and have a roof, can she pay $500 a month? Now, I don't think in the course of this case she's ever paid $500 a month. She hasn't had it to pay. But she tells me she can. I understand the state's position. I do. And Ms. Siefken will probably tell you, we've gone round and round about that. Because I get where the state is at and I get where the court is at. But the reality for Ms. Siefken as a single parent, and she'll tell you this as bluntly as she can, better than I will. She has made progress toward having a life again where she is able to make payments on this restitution. And a remand to custody will end it all. Everything will be gone. House will be gone. Her ability to parent her children will be gone. Job will be gone. The ability to make any payments will be gone. Everything that she has accomplished in terms of progress, and it's taken her a long time to get here, will be gone instantly. So, Judge, as odd as it is to say this, given the nature of this case, I would recommend that if the court do a sanction, that they do it with work release so she can keep her job, so she can make payments in restitution, and that she be given an opportunity to demonstrate that the progress that she seems to have made, that Ms. Stanfield takes about, sticks. If it does not stick, and to be honest, it may not. If it does not stick, she'll be right back where she is 6 months from now, and she'll be going off to jail, and this court and the system will be no worse off. That's all I have, Your Honor. I know Ms. Siefken will want to speak to the court.
Thank you, Mr. Watts. And statements to the court, Ms. Siefken?
I'm sorry, I'll try to get through this without crying too much, but I understand your guys' position, and I haven't always been like the model probation person. I can definitely do better and be better, and I'm tired of saying that I'm sorry or I won't do this again. I haven't been a good example for my own children, and I have nothing left. I did hit a really bad situation last summer. I lost my daughter because of my mental state. And I was with her ever since she was a baby. And I haven't seen her since last June. I was even taken from my son, who I saw all the time too. And I just recently started getting visitation back with him. It is very hard for me to get a job because of the stipulations that I signed, that I agreed to at the very beginning. No personal customer information, no money, no cards, no checks. So it is very difficult for me to even get a job, like even at Spangles. I do have a great job now, and I love it, and I feel very confident with it. I feel very comfortable for it to be a long-term situation. I'm working on trying to better myself through therapy. I go twice a week. Plus, I'm a part of a crisis video conference every Tuesday at 7 to talk about PTSD or kind of what happens. But I would definitely agree with Teresa in regards to whenever I get really depressed, I lose it all. I go back to my habits. I go back to feeling worthless. My encounters with the police and everything have a lot to do with well checks. I did have my house broken into last year because of a well check to make sure that I was okay. There has been quite a few that have come to my house just because my family has wanted to check on me. I wasn't doing anything wrong, but I guess I didn't realize that I needed to tell Miss Stanfield. And at that time, I wasn't even talking to anybody, not even my family. I really wanted to die every day. I hated myself. And I've come to a point where I'm trying not to feel that way again and do better and be better. I have a great job. I have a house and a car. I'm able to take care of those responsibilities, plus that. And I just want to be better. And if I end up leaving, I'll lose it all again. and I'll have a second eviction underneath my belt, and I'm already a felon, so it's hard to get a place to live. And I'll be back and searching for another job. That will be hard to find somebody to modify some of the things so that I can do my job. So far, I've been pretty lucky with these people modifying it so that I can. And I would definitely like the opportunity to stick with that. And then I can work towards doing better and seeing my children and being back to what I was. I've just had a hard time for a while with depression and bad relationships and losing things, being unemployed when I know I'm better and I'm more capable of doing that. So I'm very sorry. And I know that this has happened more times than enough. But I can assure you this time it's not. And if it's not, do my underline. I understand Teresa's point. She can't help me anymore. But she's the one who knows me the most right now and has seen things. And I've been honest with her and showing things and sharing things with her. And so I appreciate her very much. That's all I've got right now.
Thank you, Mitzi. Can the court has taken what Miss Norris advised under advisement, and I believe that it's correct that when you are forced and faced with these warrant to show cause matters where your probation may very well be revoked, that you turn things around and you work toward satisfactory accomplishment of task in order to avoid prison. And that's what we're here today for, whether you avoid prison or whether you go to prison. It appears to me that these are very experienced individuals that have been with the court system for a long time as prosecution, defense, and in probation. And it strikes me that they really do want the best for you and society, but there needs to be this was very ably put, I thought, a resource judgment in that there are so many resources that the courts have. And this hearing today, it frankly takes away from other matters the court needs to take care of. And but it's important, and we're going to listen and go through whatever steps we need to in regards to making sure that you receive due process. I am going to withhold disposition on your case because I am finding, and I find that your strategy to avoid prison is to be compliant. That's a good strategy. That is not a bad strategy, but you have to remain compliant with the terms and conditions of your probation. The court also understands that you have mental health issues. The court is very much aware of mental health issues. I have personally served over 25 years on the local mental health board to try to provide services to people that are suffering from mental health issues, which are just as real as if you're suffering from cancer or a heart attack. I understand that. So what the court does at this time is withhold disposition. This is hanging over your head, disposition, at this point in time. And there at court security, I would ask that we have a pencil and piece of paper to write down some subsequent dates that you're going to have to come back and be accountable to the court. I don't think I've ever had a fourth time warrant to show cause matter before the court. By the time you hit 3, you're gone. This is I believe it's a 2018 case. This is 8 years old. I think Mr. Watts brings up a good point that there wasn't much of anything brought to the attention of the court up until about 2022. The court will go through the expectations in a moment, but your next date, I am going to order that you reappear just as you've appeared today. And that is on the next warrant to show cause docket. And that is scheduled for just a moment. I believe that that would be for, and I'm going to set it out approximately 60 days. That would be my June docket. And that would be June 13, 2025 at 2:30. And I'm also going to set August 1, 2025 at 2:30. Court sets those 2 dates for accountability purposes. The court understands that it has to sit in judgment of the resources available to the court. Quite frankly, I think that everyone that is working on your case, prosecution, defense, and community corrections probation, does have your best interest at heart. The court is finding that counsel and Ms. Stanfield are being very thoughtful in regards to you, but the court expects absolute, complete compliance by yourself and will review the same on those dates that I just set forth, June 13, 2025, August 1, 2025, and will make a judgment at that point in time whether you will remain in community corrections or otherwise you'll do the balance of your sentence previously imposed upon you. Also, as I believe Mr. Watts said, well, all parties have advised, one key to the court retaining you on probation is the fact you have a good job. And as counsel's brought to the attention of the court, you have a very difficult time obtaining a job now, handling any type of money. So if you have a job, the court is supportive of gainful employment. And the court encourages you to maintain that employment, because if you don't, the consequence will be you have to go to prison. That's just as clear as I can be. So the court will reserve disposition of your case today, and we'll take these matters back up on June 13. And if you're compliant then, August 1. And if you're compliant at that point, the court will probably set you out instead of 60 days, maybe 90 days for review. But even though this is a very old case, the court is going to make sure that you do what you're supposed to do until such time as you are successfully terminated from community corrections. If that successful termination from community corrections never is going to happen because of your non-compliance, the court will revoke your community corrections at that time and order you to serve the balance of your sentence. I'm trying to be as clear and distinct as I can possibly be with you. You are as close as I've ever experienced anyone on the other side of the bench being sent to prison, but you are not at this time remanded and sent to prison. As long as you're in compliance with the community corrections program, your probation requirements. With all that being said, any further comments from, I'll start with the state.
Your Honor, do you want her to report either to the courthouse or to Mr. Watts?
Yes, you need to report either to the Butler County Judicial Building or to Mr. Watts's office on that next date, June 13. Thank you, Ms. Norris. Anything further, Ms. Stanfield?
Her probation is due to expire June 30th, and that's usually when we extend her each year. Do you want me to extend her come June 30th, or do you want to do it now?
Let's wait till the June 13 day.
Okay.
And you have to personally appear at Mr. Watts's office or at the Butler County Judicial Building to take this matter up once again by Zoom. And in all likelihood, you're going to be extended for a period of time at that point if you are successfully completing your community corrections program. Keep in mind, this is one step at a time. It's getting straight with your mental health as best you're able. It's maintaining your employment. It's trying to work through depression valleys that you experience as you go through and working through all of that. I understand this is easier said than done. And further matters to come before the court, Mr. Watts.
No, I guess I'd request a brief breakout with Ms. Stamphill on board as well when we're done here. That's all.
Thank you, Mr. Watts. There being nothing further to come before the court, court is in recess. Can we just take it up over the Zoom and take off the public aspect of the meeting?
That's fine, Your Honor.
Okay.
Your Honor, are we done with cases? And I can leave.
Yes.
Your Honor, my last one here today is Mr. Tyler McClure. I'd be requesting a quick breakout with him, if that's all right with the court.
Yes, I'd ask Mandy if she could assist you with the breakout room. And Mr. McClendon, are you and your client prepared to go back on the record?
Yes, Your Honor.
Case is entitled State of Kansas versus Tyler McClure, 24 CR 74. State of Kansas appears by Greenwood County Attorney Jill Gillette. The defendant, Mr. McClure, appears in person and by court-appointed counsel William McClendon. Also appearing at this time is Intensive Supervision Officer with Community Corrections, Ken Clausing. This matter does regularly come back before the court this date on the warrant to show cause docket. And announcements to the court, Mr. McClendon.
Your Honor, we'd be requesting a contested hearing on this matter.
All right, and the court will then refer back to the state and Miss Gillette.
We'll be calling Ken Clausing.
Mr. Clausing, if you'd raise your right hand, I'll administer an oath. You do solemnly swear the testimony you're about to give in the cause now in hearing shall be the truth, the whole truth, nothing but the truth, so help you God. And you're on mute.
I do, Your Honor.
Thank you. Please proceed. Answer slowly, distinctly. Please enunciate as best you're able. and be sure to wait until the question is asked before answering. Direct examination, Miss Gillette.
Could you please state your name for the record?
My name is Kenneth Clausing with the 13th Judicial District Community Corrections.
And how long have you been employed with Community Corrections?
Since November of 2001.
And was Mr. McClure assigned to Community Corrections at his last revocation hearing?
Yes, he was assigned to Ed Ketley.
And did he meet with Community Corrections after the hearing in a breakout room?
He did, yes.
And then after he met with Community Corrections in the breakout room after the prior revocation hearing, did he ever report or come back into Community Corrections?
There are no notes in the file for that, and Ed Ketley said he never spoke to him after the breakout room.
And has he ever tried to report to you as the primary officer for Greenwood County?
No.
And did he then abscond from his supervision immediately following his last probation revocation hearing?
Yes.
Your Honor, I will pass the witness.
Cross-examination, Mr. McClendon.
Yes, Your Honor. Mr. Clausing, did your office ever make any attempts to reach out to Mr. McClure?
The note was that he was to contact Ed Ketley the day after the hearing. That was the last thing I have on the notes.
No further questions, Your Honor.
Thank you, Mr. McClendon. Any further witnesses, Ms. Gillette?
No, Your Honor, the state will rest.
Any further evidence to present, Mr. McClendon?
Your Honor, the defense would call Mr. McClure.
Mr. McClure, if you'd raise your right hand. You do solemnly swear the testimony you're about to give in the cause now in hearing shall be the truth, the whole truth, nothing but the truth, so help you God.
Yes.
Please proceed. Mr. McClendon, please speak slowly, distinctly, enunciate as best you're able, Mr. McClure, and wait until a question is fully asked before you answer. Mr. McClendon.
Mr. McClure, why were you unable to report to Mr. Ketley?
Because I've lost my phone when I got out.
Okay. And did you have any employment at that time?
No,
Did you ever try to reach out to the Butler County office to meet with Mr. Ketley?
no, because I didn't have his contact. I lost all my information. I lost my phone. I lost his information when I got out.
Mr. McClure, are you attempting to try to go back on probation here?
Yes,
Do you think if you were to go back on probation that you would be able to contact Mr. Ketley?
yes, sir.
No further questions at this time, Your Honor.
Cross-examination by the state, Ms. Gillette.
Mr. McClure, do you know your probation officer's name?
No, ma'am, I don't.
Do you know that you can call the court and ask for your probation officer?
I did not know that. No.
And did you have Mr. McClendon as your attorney for your last revocation hearing?
Yes, ma'am.
Did you know how to reach Mr. McClendon?
No.
And
Here at the deal, yes, but when I got out, no.
And did you have Mr. McClendon's ability to look up Mr. McClendon online?
Didn't have a phone at the time.
Could you reach out to a friend? I mean, almost everyone in the world has a phone.
Yeah, but I didn't have a phone. I couldn't. My friends don't live here.
Were you around people that had phones?
No.
Could you walk to a public library and look it up?
Where I was never around a public library.
Were you ever in custody during that time?
No.
Were you arrested by Harvey County on November 16th, 2024?
Why does it matter?
Were you arrested by Harvey County on November 16th?
Yes, but I was released on a war bond.
Were you arrested in Sedgwick County on February 19th of 2025?
Yes.
And then did you stay continuously in custody until Greenwood County picked you up?
Yes.
And could you have asked any of them for information as to how to contact a probation officer?
Oh.
Your Honor, I have no more questions.
Any redirect, Mr. McClendon? Court finds that the defense does not request redirect. Subsequently, any further evidence to present for the defense, Mr. McClendon?
No, Your Honor.
The court has had the opportunity to listen to the testimony of both Mr. Clausing and Mr. McClure, and subsequently the court does find Mr. McClure to be in violation of the terms and conditions of his probation. Recommendations as to disposition, Miss Gillette?
Your Honor, the defendant had previously had a revocation. On that revocation, he took off on his probation. He was not reporting as directed, was not doing the things that were appropriate. He failed to report to his intensive supervision officer. At his sentencing, he was instructed to contact community corrections upon his release from custody. He failed to contact the program then, and attempts to locate him were unsuccessful, and his whereabouts were unknown as an absconder. He did the same thing at his revocation hearing. I believe he's intentionally non-compliant, absconding.
Your Honor, may I say something, please?
No.
Not right now,
You need to be quiet at this point.
He's in intentional non-compliance and absconder. He's been arrested in Harvey County. He was OR bond on that. And then he was arrested in Sedgwick County. I believe he's not amenable to treatment. He hasn't attended any of his treatments to date, has not kept in contact with his officers, absconded twice. I would ask that he serve his underlying sentence, that is 12 months with the Kansas Department of Corrections.
Recommendations for disposition from the defense, Mr. McClendon?
Judge, we'd be asking that he be reinstated on probation. I do think it would promote offender rehabilitation. I believe at the original sentencing, Mr. McClure was screened and approved for Senate Bill 123 plus. I think that would be a good avenue for him if he is willing and able to go back on to Senate Bill 123 and complete that probation. I think it would help him out greatly.
Thank you, Mr. McClendon. And recommendations from Community Corrections, Mr. Clausing.
In speaking with Mr. Ed Ketley, he believed that he should be revoked on this case.
Thank you, Mr. Clausing. Mr. McClure, the court does find that you are non-compliant with probation terms and conditions. Subsequently, the court does revoke your community corrections probation and orders you to serve the balance of your sentence with the Kansas Department of Corrections. That is for a 12-month period. Anything further to come before the court? Ms. Gillette?
Judge, I do need the determination as to whether or not you're assigning any fines. He has been in custody since February, and I'll be adding the jail time credit to his journal entry, and I asked the court award the jail time credit. He had 141 days on his original sentencing, and I will calculate the number of days from the February date that he was taken into custody till today. That's 2/19/25 till the present.
Court does order Mr. McClure be given credit for jail time served. Court does find Mr. McClure is without financial wherewithal for reimbursement of court-appointed attorney fees and the bids application fee. Anything further to come before the court, Mr. McClendon
No, Your Honor.
and Mr. Clausing?
No, Your Honor.
Mr. McClure, good luck to you. There being nothing further to come before the court is in recess. Have a good day.
Thank you, Your Honor.
You heard the man. Have a good day. You'd think so, but it's not. It's not for them. They think that there's no such thing as consequences. Oh, you guys, thank you so much for coming and hanging out with me. I have a very good head start on cases for tonight. So I hope to get to see you guys all again. We're going to have so much fun. Oh, thank you. I try. I've been trying more often. I love you. Oh, don't make me cry. And thank you again, S. Buford. Thank you so much. I love it. I love it. I love it. I love it. I cannot wait to install it. I'm so excited. Mini and hidden loop recording. Ooh, G sensor. Are you sure this goes in my car? Parking monitor. Super night vision. Front 160 degrees, rear 150 degrees, Wi-Fi, dual cameras, 4K and 1080p. I'm so excited. You guys just wait until I start posting trips where people drive stupid in front of me. Yeah. It'll happen. It'll happen. Yeah. S. Buford got it for me. Yes. See you next time. Hopefully tonight. Thank you guys so much. Be safe, be well, sleep sweet, and much love.